let's get into it. We've been through the pandemic and we have spoken before the show here about common problems with buyers and sellers post-pandemic.
That is the world we now live in, and there are certainly a number of common problems that we're seeing in the last 6 to 9 months.
Yes. And of course, you have mentioned in the past, whenever there's some sort of housing cycle, you will see the fallout immediately afterward.
Normally, what we see is it usually takes a couple of months. And in this cycle, and as with most cycles, it starts with fallout from the deposits. And then once the deals close, you start to see the problems that buyers are experiencing from the houses they purchased.
Let's speak about the most common over the years that I learned from you is non-disclosure cases, which I believe real estate attorneys nickname bad house cases.
Absolutely. Right now, with the non-disclosure cases, the things we're seeing the most fall into two or three categories. The first category are people that were not able to perform inspections during the pandemic for one reason or another, either because the sellers were worried about having people in the house, but the buyers still wanted to buy the house, or because they just couldn't get inspectors. They couldn't hire inspectors. There weren't enough available during the time period that their escrow was pending, and they couldn't get someone out there, and they still wanted to buy the house. So the buyers were willing to take the risk and buy the house anyway. Or a second category is they were able to do an inspection, but the seller said, "Hey, I only want you in here for 8 minutes or 10 minutes or 15 minutes." So they're rushing through the house. Or the third category was times where someone did an inspection, but they didn't notice something because, for instance, they had a mask on.
Good point. You have spoken about that in terms of limited amount of time for buyers to do inspections. They might have just a few days or a few hours. And when they're on site, the homeowner didn't want anyone in the home that long. And if they were, they're wearing masks and gloves and booties. And it was a limited inspection.
Exactly. For instance, one of the cases that we're in the middle of litigating is a buyer who bought a house, did an inspection, and they had a 20-minute inspection, and they were in there with the property inspector, and the house has a basement where there's a wine cellar. And after the buyers bought the house, they moved in, they go down to the wine cellar and they smell this really strong mildew smell. And it turns out there's a leak into the basement, and the basement behind the walls, there's significant amount of mold growth. And the seller's answer in the litigation is, you had a chance to do the inspection, and if it was really that bad, you would have noticed it. And the buyer's answer to that is, I didn't notice it because I was wearing a mask the whole 20 minutes and you can't smell anything. But as soon as I moved into the house and I walked down to the basement, you could smell it.
Now, I'm sure that is one of many cases nationwide based on limited inspections, wearing masks or not inspecting at all.
Yes. I mean, I talked to lots of different lawyers here, and we're all having the same types of cases. And I represent both buyers and sellers, so I see it from both sides of the equation. And it's a very common experience right now. I'll give you a second example, which is permits. A lot of times buyers are told that they need to go check the permit file. For 18 months, the county or the city, the buildings were closed. And the only thing you had access to was the online file. And a lot of times the online file doesn't give you the actual documents to look at, or sometimes it's incomplete. So in a lot of these instances, you have ADU units or remodels, and the buyers can't go inspect whether or not there's an actual permit, or whether the permit was signed off, or what the scope of the work was actually approved for. And then they buy the house, and the city or the county comes in and says this work was illegal, and now you're in a non-disclosure case. And the seller's answer is, you could have checked the permit file, but during the pandemic, that's not really true sometimes.
Yes. And of course, the best visit for checking permits is to physically go to the building and meet with one of the planners or building inspectors, have them explain what's in the folder and what's not.
For instance, a lot of times on the disclosure statement, the seller may say remodeling done with permits, and that may be true. But if you go inspect the actual file, what you'll see is, say, one of the bathrooms was done with the permit, but 2,000 square feet of other remodeling wasn't done with the permit.
Right. Yes. And you've seen that a lot, where they pulled the permits, they applied for the permits, they had one or two inspections and just wrapped up the construction, paid the contractor, and never received a final building clearance. on a permit?
The actual terminology for that is the final approval. So the permit is when you apply for the permit, they give you that card, and then you're supposed to have people come off and do the sign-offs on the back of it. And then that final sign-off is the actual approved permit. And a lot of people, if they're doing things that aren't to code or beyond the scope, they'll apply for the permit so that if a city official is driving around the neighborhood or checking, they see the address and they say, oh, there's a permit applied for and it must be in process. But then they never complete the permit. They never ask for the final sign off because they've done stuff beyond the scope of the permit. And then it just falls into limbo.
And this is a problem also when the seller's agent will often tell guests at the open house, the work was done with a licensed contractor in a workmanship-like manner. It was like robotic.
Correct.
Which is code for no permits.
Sometimes, or the other problem somebody has is sometimes agents are not necessarily contractors. So sometimes the owner or the contractor will hand an agent a permit and say, oh, the work was done with permits. But if an agent doesn't have the knowledge to know, I need to look at the back of the card to see if it had a final authorization for the approval, then they don't know whether it's an approved permit or not. So a lot of times there's misunderstandings. And then what ends up happening is the agent signs an avid that says, oh, the work was done with permits, but the final permit was never approved. So there's not an approved permit for the work. And now the agents made a misrepresentation, the sellers made a misrepresentation. And then in the non-disclosure case, that becomes pretty good evidence for the buyer that misrepresentations were made.
Yes, and it's tough for the real estate community as well as the consumers, because how to decipher those building inspection documents. So I've got a lot of initials and stamps.
And then you add to that during the pandemic that the buyer who is trying to go into the city office or the county office to look at the actual original permit card, and they can't get in because the office is closed, and they can't talk to anybody because everybody's working remotely or been furloughed. And it's just this void of information. The argument that lawyers are making now is that in these post-pandemic non-disclosure cases, there's even a greater reliance and greater obligation on sellers to do the disclosures truthfully and completely, because there's a lack of information available to the buyers. So what normally buyers have available for due diligence is no longer available, and that places a greater burden on the sellers to be truthful in their disclosures.
Now, this gets into also during the pandemic, my favorite real estate friend is the contingency. And a lot of contingencies were asked to stay out in the street at the curb. Don't come to our property. No contingencies on this. For the lay people, contingency is a right for a buyer to walk away based on inspections or the property not approving. Can you speak about, combine the importance of homes that were bought without contingencies plus these non-disclosure issues?
This is an issue that's unique to California and more unique to the specific area in the Bay Area where the market was so hot at the time, where you're right, people were buying houses during the pandemic in a rising market without contingencies, meaning, like you said, without the right to cancel the contract and get their deposit back, while at the same time knowing that they were performing very limited inspections with less ability to do their own due diligence, while still taking massive risks in the amount of money they were buying houses. So now we have these lawsuits where buyers have bought houses with $200,000, $300,000, $400,000 problems that they're saying were not disclosed. And the seller turns around with some pretty good defenses, which is, Mr. and Mrs. Buyer, you took the risk to buy this house without any contingencies. You took the risk to buy this house with no inspections or very limited inspections. You knew all of that when you bought it. And then in most cases, the seller says, the issue you're complaining about, I didn't know about. I don't go crawl around the foundation. I don't go crawl around the attic. I didn't know the roof was leaking. I didn't know the foundation was crumbling. And because you chose to assume the risk by buying this without inspections, you now have a house and it's your obligation to fix your own house. And sometimes those defenses can be pretty compelling in a lawsuit.
Now, conversely, other situations where the seller will say, I relied on my agent, and the buyer says, I relied on my agent, and the agents put this transaction together. It's what I call agent driven, where the listing agent will say, oh, you don't need inspections, or we'll just give them our seller bought pre-sale inspections and then call it a day.
I think the reality in a real estate transaction now is, to lay people, especially first-time buyers or sellers, the forms are very intimidating, right? You're filling out 50, 60 pages of documents. And if an agent doesn't provide, especially a seller, with the information that, hey, out of all of these forms, the transfer disclosure statement, the seller property questionnaire, those are the most important, because those are the things that buyers are going to be relying upon the most. If you get sued later on for non-disclosure, these are the two documents we're going to be looking at the most closely. These are the documents we need to go through and make sure the answers are the most accurate. If you check yes to something, that there's something that's being disclosed as a negative condition, we need to give a full explanation. If we need to do the text overflow addendum and add extra pages to it, then we need to do that. If agents do that, they're doing a really good job. If agents don't do that, if agents just hand them the forms and pass the forms along to the buyer without double checking it, then I think that's more of kind of the agent driven transaction that's just going through the process. And that's where mistakes get made.
That's a good point. And of course, that's where your savvy comes in, growing up in a real estate tree there of realtors, is that you've also mentioned in the past that these seller questionnaires have to match across their transaction. In other words, if they bought the house 5 years ago, those pieces of information should also be in the current disclosure seller questionnaires.
Yes, and it's especially important as transactions get closer together. So over the course, if you bought a house 5 years before and now you're selling it, a lot of times people may have lost the forms between then, or the forms may have changed, or the condition of the house may have changed. But where it becomes really important is if you've only bought the house within a year or two and you've done significant amounts of work to it, so you've changed the condition of the house, it's important that the forms, if you buy a house and you say there were permits to this scope of work, but now we've completely remodeled the house without permits, and then you go ahead and check work done with permits, but that is referring to work that was done before you bought it, and that work's now been ripped out and replaced with unpermitted work, that's no longer true. The other example is, a lot of times somebody says, when I filled out the form when I bought it, I didn't know the answer, so I checked no or I don't know. And it's like, but wait a second, you just bought the house a year ago and the forms you bought it with had the information on it. Those did disclose the problems to you, and now you're not disclosing those same problems to somebody else claiming you didn't know, but you did know, you just maybe forgot or didn't go back and look. And that's when, if you buy a house a year apart and something was disclosed to you on the forms and you didn't disclose it to somebody else, that becomes a significant problem.
There you go. Now, this also, and we'll close out this section here with stating that it's a good idea for buyers to get their own inspections for the chimney inspection, roof inspection, termite, whole house property, foundation, and have a contingency. Would you agree?
So the issue with contingencies and number of inspections becomes personal at some level, because it's a matter of risk. And at the end of the day, an older attorney, when I was first starting, said, the best way to describe an attorney is we peddle risk. At the end of the day, we advise people as to what their level of risk is. And a conservative buyer, somebody who wants to be really cautious and make sure they're really doing their due diligence, should do all of their inspections that are available to them. And they should retain a property condition contingency, so that if they find something wrong with the house, then they can cancel the contract and get their deposit back. Somebody who is more willing to take a risk is willing to either do less inspections and or put their deposit at risk. So if they do cancel the contract, they're okay losing their deposit. And then there are people that fall all in between that spectrum. The problem that we have in this market is this custom arose that people buy houses without contingencies. So the conservative person that wants to retain their contingency often finds it difficult to get an offer accepted because there's so many other people willing to waive that contingency that the non-contingent offers look more attractive to sellers. So the person that's conservative and wants to retain their contingency needs to stay firm to that position and wait until they find a house and a seller that is mutually agreeable with them.
That also goes, for instance, first-time buyer versus a person that's bought and sold 5 or 6 times before.
Yes.
Totally different buyer.
And they may have very different risks. And the other thing is the person that saved all of their money and their entire life savings is in their deposit versus somebody who has extra income, extra money, and that deposit may not mean as much to their lifestyle as to somebody else, right? Those people are going to have different risk levels.
Perfect. Okay, next up, boundary cases. One of my all-time favorite. Of course, this is a staple of real estate attorneys at their seminars and in their practice. Tony, can you speak about the types of cases regarding boundary disputes?
I place this in our discussion of post-pandemic cases because for whatever reason, after the pandemic, and maybe it's because people were more locked into their homes, whether they were townhomes or single family homes or houses out on acreage, but people seem to have become very possessive over their boundary lines. And we're seeing a very big spike in these types of cases. Fence disputes between neighbors, people doing surveys, finding out that the fence is off 4 inches, 6 inches, a foot, and litigating, having lawsuits over, we want the fence moved to the property line. Your irrigation line is across the property line. We have another case where it's lots out on 40-acre lots where there are 2 different access roads. There's one access road that only takes 5 minutes to get to the development and another one that takes 20 minutes to get there. And a person who only has an easement on the 20-minute access road is suing to get the right to use the easement on the 5-minute access road. And the people that have the access on the 5-minute road are excluding him for no other reason than that's our road. We don't want any more users on it. So at all levels, there are a market increase of people fighting over their possessory rights of their land right now.
And I've heard this throughout the real estate attorney community. During the pandemic, people, of course, the home changed dramatically in all ways. And whether it was a condo, townhouse, apartment, or as you mentioned, land, now people are really putting up their stakes and claiming their territory.
Yes, and I think it has to do also with, as people are working from home, they're less tolerant of noise. They're less tolerant of traffic and other things, noise from neighbors, noise from traffic, because they're working from home. So they need different conditions versus when people left at 8 a.m. and came back at 6, what happened around your house during the day didn't really matter to you.
And that reminds me, when I was a young realtor working with relocation buyers, and I was speaking about the quality of life in this particular condo, townhouse, house. And the transferee would often say, Pat, when I'm at home, most of the time my eyes are closed,
Right.
especially they're coming to California. So that changed dramatically. All right. What about with condo townhouses when you have one unit above the other or the walls? Now you have a dispute with the HOA perhaps, as well as the neighbor?
I'll give you one specific case where we had out in North San Jose where the upstairs neighbor changed the flooring from carpet to hardwood, which increased the sound that was being transmitted below. And the person below was trying to work from home. The person above had been, during the lockdown, had now had to stay in the house with their 2 young kids who were running around, jumping around. And the HOA documents allowed hardwood flooring, which is not common in upstairs, downstairs units. So it became a big lawsuit. The downstairs neighbor sued the upstairs neighbor in the HOA, sued the upstairs neighbor for nuisance. And the upstairs neighbor's defense was, the state of California is locking me into my house. My 4-year-old and 2-year-old playing in the house cannot be considered a nuisance. And then sued the downstairs neighbor, sued the HOA essentially for making negligent rules. Like, how could you possibly have a rule system that allows hardwood floor? And the HOA's defense was, you knew the rules when you bought, and whether you liked them or disliked them, you agreed to them when you bought. Now, ultimately, that case ended up settling, but it's the lockdown created a bunch of very difficult situations for people.
Yes, I was in a similar situation with a condo 25 years ago when they were not made well. And upstairs occupant would come home late from work and walk across the floor. Everybody could hear the walking. So the HOA, to avoid a lawsuit, took the ceiling down and put in all sorts of, at that time, state-of-the-art insulation and layers of sheetrock and construction to dampen the noise.
Right.
I'm sure sometimes the HOA can step up and make things right. Tony, let's talk about fences. Moving a fence, it's too tall, it's too short, it's falling down, it's on the 1 foot over. What do you have on that for the listeners?
A lot of the areas like old Santa Clara, old Willow Glen, a lot of those older houses, the fences and the property lines don't necessarily match. And then when people come in the 50s or 60s or 70s, they put the new fence where the old fence was, which wasn't necessarily on the property line. And everybody got along. Nobody really cared. 6 inches, 4 inches, 12 inches here or there. Then what happens is we enter this new era where new buyer moves in, they knock down the old house, they do a survey, and the surveyor comes back and says, all your fences are off. You're 3 inches off on this side, you're 5 inches off on the back, you're 7 inches is off on the right. And now the new buyer on the right side, where your house encroaches into your neighbor, they don't want to worry about that. But where you're losing 5 inches and 7 inches on the other side, they want to go to those neighbors and say, we want to move the fence over to the property line. And the reason is because people are now building these monster houses on the lot right up to the setback line.
Yep.
So they're designing the house 5 foot from the property line. That doesn't work if the fence is 7 inches inside the property line. They need to get the fence moved over to the property lines. And the first interaction they have with their new neighbor is they knock on the door, they send their contractor over, they say, there's an encroachment, we're going to move the fence over to the property line. You need to move your flower bed, your irrigation line, whatever you have in that 7 inches.
Sure.
And right off the bat, it's acrimonious. And a lot of times the people that live they've been there 10, 15, 40 years, and they're not real excited about having a fence that's perfectly fine, ripped out and moved over 7 inches. And we have 2 different pending cases where their clients are actually in lawsuits over moving a fence. And you're spending $20,000, $30,000, $40,000 in legal fees over less than a foot. But to a lot of people, it's a matter of principle. That's where the fence has been, and that's where the fence is going to stay.
Yes, and I understand that former owners could be involved. I know I've heard of that with real estate attorneys, that they will go to the past seller and the past buyer and so on down the line. That information came down.
So the way that comes up, it comes up in one of 2 ways. So if a buyer buys a house, finds out the property is off, the fence is off the property line, and goes to the neighbor, and the neighbor says, oh, no, the previous owner gave me an easement and said, I'm allowed to put my patio, we moved the fence there so my patio furniture will fit. That buyer then is going to go back to the seller and say, I have a non-disclosure claim. You didn't tell me, you never disclosed that you gave an easement to the neighbor. And the seller comes back and says, I didn't give him an easement. I just said, as long as I'm not using it, he can put his patio furniture there. Just tell him to move his patio furniture. Now you got 3 people involved in the lawsuit.
Yep. Okay. Now, I had a case, I was representing a seller in Marin County on a sloped hill, San Anselmo. And throughout the process, I was doing the disclosures like you recommend. And I said, what about that fence? It was a see-through wire fence. And covered with ivy between the two nice homes. And he said, yeah, it's not really on the true border. And we started to talk about something, and I said, back up, Tony Ventura would want me to ask about that, not on the true border. What I did, he said, I have a survey somewhere. So we got the survey out, and I said, let's disclose this to the new buyer, and let's disclose it to the next door neighbor that this could become an issue. So I made everyone aware of it, the next door neighbor, as well as the future buyers, in the form of disclosures with a letter explaining that this fence was not on the true boundary line.
In that type of situation, the buyer has two options. They can either fix it or they can disclose what they know. So you're correct. What you do is you disclose, I don't think it's on the correct border, and here's the survey I have, so that if the buyer's interested, the buyer can go figure it out, or the buyer can go talk to the neighbor and they can try to resolve it before the buyer closes escrow.
Now, we also have what's called a spite fence, situations like that where the neighbor might paint it purple. I had that once where I was representing repeat clients going from a townhouse to a single family home, and it was a cookie cutter 60 by 100 foot lot. And the next door neighbor had 4 feet of my buyer client's lawn with flowers. It had been, like you mentioned, for decades. So they moved in and said, excuse us, we want our lawn back. And so I don't think there was any attorneys involved, but they finally got their lawn back. So the next door neighbor painted their fence bright fluorescent purple.
I've unfortunately seen things unravel. So for instance, the more classic spite fence is when people plant massive trees as a wall instead of a physical fence. So for instance, someone plants 10 redwood trees side by side. I actually had a case where there was a 6-foot wood fence. The neighbor on one side didn't like it, so they put these 8-foot tall stuffed animals that stared over the fence into the other neighbor's living room. So the other neighbor's answer was they literally put a row of redwood trees in front of the fence to put the other house into darkness, essentially.
Oh my gosh.
When you get these boundary disputes, it can turn into the Hatfield and McCoys pretty quickly.
Tony, let's talk about specific performance cases. What's the difference between specific performance cases with a buyer versus a seller?
What specific performance means is it's a buyer suing a seller, but instead of suing for monetary damage, they're suing to enforce the contract. They're suing to essentially make the court sign the grant deed for the seller so that the buyer ends up with the property. So procedurally, the way it works is the buyer deposits the money to buy the house into the court's trust fund, and the court then pays off the liens, gives any remainder money to the seller. And if the seller still refuses to sign the grant deed, the clerk of the court will sign it and convey title to the buyer.
Now, I've heard in the past that it's real hard to force a buyer to buy a house.
Yes, it is. So this is a dispute among lawyers where some lawyers will tell you that this remedy does exist. I will tell you that I fall under the camp that I believe this is more theoretical. This is more one of those law school remedies than anything else. Legally speaking, the law says that a seller can seek specific performance, but I would argue that our contracts, when the liquidated damage clause is initialed, limit the seller's remedy to the deposit. So that if the buyer breaches, the whole point of the liquidated damage clause is that the buyer only has to forfeit their deposit, that you can't then make the buyer buy the property. Some lawyers would argue, like for instance, in an example where the buyer doesn't put the money into escrow, they don't put up their earnest money deposit. Some lawyers will argue because the buyer never funded the deposit, then the liquidated damage clause doesn't apply. And because of that, then specific performance is a remedy. But one of the other elements of specific performance is you have to prove monetary damage would not be sufficient. When you're a buyer buying a property, that's easy to meet because the law says real property is unique. So when you say I'm buying my dream house, that's unique and money can't replace that. But when you're a seller, and you sell a house for $1 million and the buyer backs out and you end up selling it for 900,000, you lost $100,000. That's not unique. The judge can just give you a judgment for $100,000 against the buyer. So while it's theoretically possible, I'm not sure it's realistic. And I've been doing this 25 years and I've yet to actually see that lawsuit.
You've mentioned in the past, real estate agents should not be counseling a buyer or seller to cancel the sale without consulting a real estate attorney.
I think, and as you've heard me say in the past, I think agents are too casual in advice they give when it comes to cancellations, because there's repercussions and consequences that agents don't necessarily understand. And my advice is that agents should refer decisions to cancel contracts to lawyers, so that lawyers essentially become the shield for the agent. The agent then is no longer liable. Whatever happens, the agent can say, I referred you to a lawyer, whatever decisions were made, it's the lawyer's fault if something goes wrong. Because a lot of times, I'll give you a common example. The agent will tell the seller, well, go ahead and cancel the contract, you'll get your deposit back. You'll get to keep the deposit, I'm sorry. But a lot of times, the answer, there's a statute that applies where if the house sells for the same amount of money or more, the buyer has an argument that the seller wasn't damaged and the buyer can get the deposit back. And if parties have incurred attorney's fees, so if the buyer goes out and gets a lawyer and then has to go to mediation or arbitration to make that argument, then the seller may become responsible for paying the buyer's legal fees. And then the seller turns around to the agent and says, wait a second, I only did this because you told me I was going to get the deposit, and now I got to pay this person's legal fees.
Yes, that's a good point, because you've mentioned what types of cases in every type of market is disputes over the deposit.
Correct.
Now, in terms of foreclosures, we do see that in every type of market, because a lot of the foreclosures now have loans that were generated during the Great Recession.
Correct.
Or mom and dad, grandfather passes away and the adult grandchildren are not paying the mortgage.
Correct. Yeah. And right now, so we're in this unique period where we had the Great Recession, and from 2012 to 2015, all these new loans were issued. And then there was this great period of prosperity where houses were sold and houses were refinanced. And now the market's starting to turn. And what we don't know yet is what percentage of those loans are going to turn out to be short-term adjustables like before, or how many people refinanced and took equity out of property. So what is a decline in the market going to do? Is this raise in interest rates going to push people into foreclosure in the short term or not? So right now, I haven't seen anything yet in terms of that. So we're in a wait and see to see if the foreclosures are going to spike. Where we are seeing foreclosures are in reverse mortgages, where people have passed away, and we're seeing the reverse mortgage lenders trying to foreclose because they want to get out while the property values are still high, because they're worried that as the market declines, then they may not either recover as much as they're owed, or they may end up recovering less because their remedy's limited to whatever the property sells for.
Now, for the lay people, a reverse mortgage is for older adults who are receiving money from a lender, and as soon as the older adult passes or moves out permanently, within so many months, the lender can call the loan due.
Correct. So be an example of a case that I have now, which is a person borrowed $400,000 when they were 70. So they borrowed money, and the house at the time was worth like $700,000. They borrowed $400,000. One of the benefits of a reverse mortgage is you don't have to make mortgage payments. So the interest just accumulates. So the debt accumulates. This person lived 26 years after they took out the loan. So the $400,000 at whatever 6.5% interest over 26 years became $1 million something. Now the property at one point was worth $1.4 million, so the lender wasn't too worried. then the person passes away. Now the property is declining, and it's to the point where the value of the property is less than what the loan is worth. So now the reverse lender is losing money every month as the market declines, and they've become pretty aggressive and actually ended up doing a foreclosure sale that we had to have set aside.
Wow. Tony, what about short sales? Tony, can you please briefly describe the difference between a foreclosure and a short sale?
A foreclosure is when somebody defaults on their loan and the lender, in order to get paid back, forecloses on the house, meaning forces the sale of the house to get whatever the lender can get to either repay the loan or repay a portion of the loan. What a short sale is when the seller, the owner of the home, goes to sell the house before a foreclosure can occur and asks the lender to excuse part of the debt. So for instance, a house is worth $1 million, but the owner owes $1.2 million. So in order to sell that house, the seller needs the lender to excuse $200,000 of that loan in order to convey clear title to the buyer. So the reason it's referred to as short sale is the lender needs to take less money than they're actually owed. So that excusing the $200,000 of debt, that's the selling short part. You're selling for less than is actually owed on your loan.
Now, that's not to say that the homeowner is off the hook, because when the bank reports a loss to Uncle Sam, then Uncle Sam is going to be looking to see who had a gain, and that the homeowner could receive a 1099 for the bank's loss.
Correct. The seller will receive a 1099 for the excused part of the debt because it's treated as income. So in that example, the seller will get a 1099 for $200,000 of essentially income because debt was excused. Now, if it was the owner, if one single person owned that home and they lived in that home, they have a $250,000 exemption for the first $250,000 of excused debt. If it's a married couple, they have a $500,000 exemption to excused debt that they won't have to pay tax on.
Right, because during the Great Recession, a lot of families got hit hard. And before that, for that matter, right?
And sometimes during the Great Recession, unfortunately, some people owed more than $500,000. The short sales were more than $500,000. So the exemption wasn't enough. And also sometimes what we saw during the Great Recession was people were being foreclosed on rental properties. That what people were doing is they were borrowing money from their primary residence to buy rental properties and then losing the rental properties in foreclosures. That exemption doesn't apply to rental properties. So if you had $200,000 excused on a rental loan, you owed tax on that.
I know one of your favorite topics. It's one of mine, flippers, home flippers. I know you've spoken in the past about home flippers and the pros and cons of a successful home flip. Can you first describe what is home flipping and how does it relate to the general public?
I think the simplest way to explain it is a flipper is somebody who buys a house, does some level of remodeling, and then sells the house for a profit in a short period of time. So for example, somebody who buys a house, spends $100,000 remodeling it, and then sells it 6 months later for a $400,000 profit to a buyer. And the reason this is risky to buyers, there's two reasons. The first is a lot of times the buyers don't know the level of work that was done on the remodel. You don't know if it was superficial. You don't know what was covered up. So for instance, the seller can say, we removed the floors, we removed the cabinets, and basically describes they did all the superficial things you can see. But what you don't know is, did they find dry rot or mildew or mold or a cracked foundation that they just covered up and didn't fix and didn't disclose to you? And then the second thing is a lot of times flippers hold title in LLCs that don't have any assets. So that if you do have a non-disclosure claim and they did cover up a cracked foundation, when you go to sue them, you're suing an LLC with no assets and no money and nobody you can find. So even if you have a claim, it's not collectible.
That's why it's very important for the real estate agent representing a home flipper, the seller, or for the buyer for that matter, to be extra careful on the condition of the property and the history of the property, because they will be in the bullseye zone.
That is true. I do not mean to disparage an industry. There are a
Correct.
lot of people who do flipping that do it very responsibly. But what I think is important for agents to understand is if you represent a buyer, especially a first-time buyer or somebody who is stretching to go into a house, it is very important that you do due diligence. If they're going to buy a house that's being flipped, that you do due diligence on what exactly was done. Make sure there's very thorough inspections being done, and make sure that, can you check the history of this flipper? Do they have other properties? Do they have previous properties that have been flipped? Are they in litigation? Or is it somebody that's local? Is it somebody that stands behind their work? Because the reality is, if it's an LLC, like if the house your clients are trying to buy is 123 Main Street, and the owner of the house is 123 Main Street LLC, and after this house is sold, there may not be anyone to find or anyone to sue, and it may just disappear like Kaiser Sose into the night. This may not be the best risk to take for your first-time buyers who have all of their money invested in it and no extra money if something goes wrong.
Excellent point. Same thing with the real estate agents. And of course, there is great home flippers and reputable builders. I think I was involved in one of the first in Silicon Valley, and it was fast and loose, and it looked good, but they put a new bathroom over a bad bathroom. So underneath the house, the floorboards were rotted, and a lot of disputes between the inspectors. And I finally had to keep crawling under the house and take pictures and make sure things were taken care of.
What happens is flippers want to do the superficial cosmetic things that can be done fast. So in the cases that we litigate, what you find is they don't want to fix foundation problems. They don't want to fix floor leveling problems. They don't want to fix soil problems or water drainage problems or roof leak problems. They just want to rip out the floors and the carpets and the bathrooms and the kitchens and replace it and make it look shiny new so the pictures look fantastic, and then sell it.
Yep.
And if a buyer buys it and then finds out that the brand new hardwood floor is unlevel because the settlement issues are $300,000 to fix, and then you sue, a lot of times the flipper's answer is, look, I only owned this house for 4 months in the summer. It never rained. I didn't know it was going to settle. And that may very well be true.
Now, you have spoken in the past about, oftentimes, of course, that's the pitch. Real estate agents, I get this probably once a month. Somebody comes to me and says, Pat, if you find me a home that I could flip, I'll have you be the buyer's agent, and then later you'll be the seller's agent. So I know you've had cases like that. You spoke of one, I guess it was over an 8-month period, and the agent did not look at the disclosures from the purchase to the sale. Nothing matched in terms of disclosures.
So what happens in this case is the flipper buys the house and receives a set of disclosures. He receives the TDS and the questionnaire, then uses the same agent to sell the house 8 months later. And the agent hands them the forms, the disclosures to fill out. And the agent basically just takes the forms and then hands them to the new buyer.
Yep.
And doesn't go back and compare the two. And
Sure.
It turns out there's mistakes and there's contradictions on the forms where things were disclosed to the flipper when they bought the house that the flipper is not disclosing in the sale, and the agent doesn't catch them. Then when the lawsuit arises, the agent is sued for negligence and breach of fiduciary or breach of duty on the grounds that part of what falls within your standard of care is, since you were the same agent, is making you do your avid. You need to check and say that this is what was disclosed to my one and the transaction 8 months ago, or at least tell your clients they need to fill out the forms accurately.
Yes, that could be really tough for an agent because there's what could be considered, I believe you call it active concealment, if things
Correct.
are not disclosed. TDS, transfer disclosure statement. Every state has one, right? That's a mandatory questionnaire. Speaking of transfer disclosure statement and seller questionnaires, what about the garage conversion into an alternative dwelling unit.
We see a lot of that in litigation where what happens is somebody either builds a garage with a permit or buys a house that has a permitted garage and then converts it to an ADU without a permit. And then sometimes it even gets sold that way without a permit, then gets sold the second time without a permit. And eventually someone starts to disclose, whether intentionally or unintentionally, that the ADU has a permit because they've either been told that or it's happened for so long, or they look at the permit file and what they see is they see the permit for the original construction of the garage. And they don't understand the distinction between it was permitted as a garage, it wasn't permitted as living space. And then eventually what happens is somebody buys it with the disclosure that says this is a permitted ADU. They buy it to rent it out. Rents here are, you can get $1,500, $2,000 for an ADU. Then the city comes in and says, you have an illegally converted ADU. You need to rip it out or at least return it back to a garage. The buyer sues for non-disclosure and says, I'm losing, because I lost that, I'm losing $2,000 a month for the 10, 15 years I was going to own this. And now that's a $300,000 claim.
TDS, transfer disclosure statement. In California, we have the seller questionnaire statement. So there's a couple hundred questions there. You have mentioned in the past, if a seller checks the box, meaning, yes, we did have a leak or there was settlement, there has to be further explanation.
What the form says on most of those questions is if you check yes, then you have to explain. And what we see in the litigation is a lot of times somebody will check yes and then not have an explanation, or they'll have an explanation that is a word or two that is nonsensical. So for instance, the question will be, is there water intrusion? And then the explanation will say floor. Oh, okay, like the floor where or how much or what is the cause? And part of the duty of the agent is to go through those forms. If you're the listing agent, is to go through those forms, make sure that the seller, number one, fills out and answers every question. So there's no blank lines. And then anywhere there's a yes and there's an explanation required, make sure that there's an explanation provided and that the explanation makes sense. Put yourself in the shoes that if you were representing the buyer and you received this form, would it make sense to you? Would it place you on notice of what the problem is? Would it give you enough information so that you could take this and know what you were supposed to investigate further?
Tony, we haven't spoken about the whole house inspector, depending on where you are in the country, property inspection, home inspection, whole house inspection. The inspector is also involved in litigation as well, correct?
Yes. I'd like to take a minute to talk about one specific story, because a lot of times buyers can be very frustrated with home inspections because you get these very long reports, but a lot of times the reports have information. I couldn't get to this area. I couldn't get to that area. Hire somebody else to do this, hire somebody else to do that. But at the same point, the whole point that the reason the buyer's hiring that inspector is to substantively tell them what is wrong with this house, or is anything wrong? And if so, what is it? Because what the buyer's really looking for is, should I buy this house or not? And from a seller's perspective, a lot of times in our area, the seller hires the inspector ahead of time to make the report available to show people there's nothing wrong with this house, or there's minimal things wrong with this house, so that if you buy this house, you're buying a house that's in good shape. So one of the cases that we have is a case against a home inspection company. So the person's about to place the house on the market, and they get a home inspection report done. And the home inspection report says, the inspector goes out and says, there's a problem with the foundation and the foundation is failing, and writes the report and sends it back to the agent. And the agent puts the report on the MLS. And
MLS, multiple listing service.
It puts it on the multiple listing service. So the service that all the other agents and all the other potential buyers have access to has this report that says the foundation on this home has failed. So people think that if you buy this house, you need to do significant work to fix the foundation. The sellers don't think that's true. So the sellers call the inspection company, and the inspection company says, well, that was an apprentice inspector, and we'll go back out and look at it. And they send a senior person out, and the senior person goes out and says, oh, he made a mistake. The foundation's fine.
Uh-oh.
So they issue a corrected report, change the language, and add an amendment that says the inspection's fine. But this whole process takes a month. So the amended report gets put up on the multiple listing service, but now the property's been sitting there for a month and no one's making any offers for it. And in this market at the time, a month, properties are selling within a week or 10 days. And now this property has been sitting there a month with a report that says the foundation needs to be fixed and now an amendment to it. So the argument that the seller is trying to make is that this report damaged the value of their property, that no one wanted to buy the property or ended up paying less for the property
Oh,
as a result of the report. And the ultimate question is, can inspectors be held liable for making mistakes on reports, even if they ultimately fix them, if you can prove that it causes a reduced sales price? And in this case, there's a house essentially around the corner, same size, dimension, and makeup, that ended up selling for $200,000 more the same week.
oh,
So that case is currently being litigated, and we'll see how it turns out.
on the same topic before you go, if a home inspector notices, or generalist notice that there's a crack in the foundation, they often will say, refer to a specialist. And the homeowner and the real estate agents involved should bring out a foundation expert to write a report on that crack. Would that be a good idea, Tony?
Yes, absolutely. One of the best things that the home inspection report does essentially is find red flags.
Yep.
What you're doing is you're sending somebody out for $500, $600, $700, whatever they charge, and you're finding somebody with experience to go out and find red flags. Where are there cracks that there shouldn't be? Is there water where there shouldn't be? Is there effervescence where there shouldn't be? And pointing out like, hey, you should have somebody with more experience or more specialty experience come look at that. Because when you're buying a house, there's certain things that are minor, and then there's certain things that can be major, right? Water leaks, drainage issues, roof leaks, foundation leaks, or foundation issues. Those tend to be the big ticket items. So those are the things that a good home inspector can call out to tell you, hey, that crack in the foundation looks like it's getting bigger, looks like it's in a pier. You should have a foundation expert, come look at that.
What I'd like to do is have two reputable foundation experts come out, write a report on it, and if the seller is unable or unwilling to fix it, now we have two opinions from experts that we can include in those seller disclosures to prospective buyers.
If I could leave with two thoughts, one for a buyer, one for a seller, it would be this. For a buyer, it would be, do your due diligence, because that is the period of time when you can find out what's wrong with the house and have an idea of what you may need to spend after the close of escrow, because you really don't want to get in a lawsuit. And for a seller, it's to understand where you should spend your time when you sell a house, and that is filling out your disclosures. Because once the close of escrow occurs, the most likely thing you can be sued for is non-disclosure, because it's an as-is sale. And in an as-is sale, the only thing you can really be sued for is not disclosing something. So when we look back on an as-is sale, we're looking back at what you disclosed, and that's not the time you want to figure out that you only spent 15 minutes on what's the most likely thing to be sued for. So as an agent, I would be recommending that buyers do the due diligence that's necessary, and I would be recommending sellers spend adequate time on their disclosures, because at the end of the day, that's where buyers and sellers have the most risk.
Now, oftentimes we have sellers in a divorce or in different locations, and one seller fills it out. That's probably not a good idea.
It is not the best idea. I think in a divorce situation, I think both spouses should fill it out, even if the spouse that's not in the area is filling things out saying, I don't know, I don't live there. I think it's at least good the out of the area spouse at least fills out the form.
And last point, the seller has to fill this out, not their agent or their nephew. It's in the seller's pen.
The seller needs to fill it out, even if it's a rental property and the seller doesn't know anything. The seller still needs to fill it out to the best of their ability.
Tony, thanks again for your time. You've always been a wonderful guest, and we hope to see you real soon.
All right. Thank you, Pat.